Intellectual property rights and the development and use of digital materials. E-learning professionals are increasingly creating educational materials that are offered on wide scale globally. E-learning practitioners crave access and vital to legal information that will assist them in their content development, delivery, and management. Therefore, knowledge about intellectual property rights information is vital for practitioners, individuals, students, digital libraries, and repositories, as it records who owns the e-learning resources, who can access it and use it, and under what conditions the resources is made available. Property rights provide certain exclusive rights to the inventors or creators of the property in order to enable them to reap commercial benefits from their creative efforts or reputation. The effective application of intellectual property rights in the creation, development, and implementation of e-learning courses is a critical component in the field of education, as it plays its part in a knowledge-based economy. For example, in the area of research, in America, passage of the Bayh-Dole Act in 1980 enabled institutions of higher education to own the intellectual property generated by their own faculty and staff under federal government research grants. As a result, institutions and some faculty members have been able to reap enormous profits from state-supported research and invention of commercial value. In the Philippines, the IFAFIL has partnered with the CHED and its latest effort to institutionalize intellectual property learning into the country's colleges and universities, a move seen to accelerate the commercialization success of innovation and inventions developed in the campuses. Intellectual property law seeks to balance the competing interests of creators' ownership and control over his or her works with the public's right to access and use of such work. As a general rule and legally, intellectual property produced in the course of employment belongs to the employer. But, traditionally, for example, individual members of academic staff in higher education have control in the intellectual property in their publication. It is therefore vital that developers, practitioners, and consumers of e-learning content have a clear idea and understanding of what is permissible with the product of their labors and what is impermissible. On the one hand, creators have the right to profit, protect, and generally control use of their own creative endeavors. On the other hand, the law places limits on the period of the ownership, and in the case of copyright, expressly permits certain fair use of this material without the need for permission from or payment to the creator. Ultimately, the law provides profit incentive and ownership protections to those who are responsible for creating intellectual property, while at the same time ensuring that their control is not held so closely that it restricts all access or prohibits the development of new works that may be inspired by these protected materials. Universities and lecturers cannot protect the educational information of the content of lectures and seminars, educational courses, and ideas. Thanks to the internet, which serves as a domain of information, a lot of people receive uncontrolled access to educational information through it, according to Mingaleva and Mirsky. Although the intellectual property rights protect their intellectual property, the internet world is making it hard. Copyright of the lecturer will be infringed when the content of his or her lectures is sold or offered or exposed for sale or hire. The ideas generated by the lecturers and tutors during educational process ought to be protected as intellectual property.